Good afternoon. Today is Friday, December the 20th, 2019. Notice has been given of a special meeting of Commissioners Court of Grimes County, Texas, to be held this date at this time, 3:30 in the afternoon, at 114 West Buffington Avenue in Anderson, Texas. The meeting has been now called to order. We'll go to agenda item number 2. Commissioner Mallett, Precinct 1, discuss and approve contract with Collier. Discuss and approve contract with Collier Construction for new Justice Center.
Well, I guess the attorney, you've looked at the contract. There's been some back and forth discussion, I guess, on some clarification with PGAL, I believe.
Yeah. That I got that from Leon, and then this is what you said.
Okay, when was that meeting we had? We had a meeting yesterday?
Yes,
All
sir.
run together. I talked to Talita and said in that final contract document that I had some concerns about the way the liquidated damage provision was phrased. And she went back to Michael to ask Michael to make some changes to it. I got the changes that he made from Mary. She sent yesterday, I think at 6 o'clock. I saw him this morning. And there wasn't a definition, or we weren't defining what substantial completion was. In fact, it was in lowercase, and whether that's significant to you, it's significant to me. When you define a term and you define it as a capital letter that begins it, then you're referring to the definition that's found somewhere else. You're defining that term. Well, substantial completion is defined, but it's defined not in A101 2017, but in 201, the other document which contains the general terms and conditions. So what the language that was proposed from Michael that I read this morning didn't seem to clarify what the intent of the parties was. And so I took one last stab at it. Of course, I prefer my language. You guys may disagree. It's your contract. But what I did was I think we all agree in principle that we're putting in there $1,000 a day if it goes, if substantial completion is not had within 365 days of the date of commencement. I think everybody's on that same page. I just tried to clear it up to define what substantial completion was, and Michael had put in there something about unless the delays are not caused by the contractor, which is fine, but that mechanism is already in that general rules and conditions. Under Article 15, the contractor can file a claim with the architect and say, act of God or some other issue that wasn't my fault as the contractor, and I need an extension of time. So we didn't need to talk about that or tinker with that language in the liquidated damage provision. We just need to reference Article 15 and the general conditions. So I sent an email to you all today with my proposal, and I wanted Mr. Collier to see it, and Mary just dropped my email in, and he hasn't had an opportunity to see it, but I want him to see it.
We will certainly give him an opportunity to review.
And if anybody hadn't seen the email, I'll be happy to read it.
I muddled through it.
Ha! I got you. I know it's lawyer language, but I will tell you this, you can...
Would you walk us through it so Mr. Collier can follow along with what he has in hand?
You bet. In fact, now that he's got my entire email, I'd rather just cover the whole thing. So I'll start with my first point, and that is, keep in mind that under paragraph 3.1, that the date of commencement is the later of those three things. Either receipt of this fully executed agreement, or the notice to proceed from the architect, or the receipt by the contractor of all necessary permits. Now, I don't know what permits are necessary. Mr. Collier can certainly tell us, but you all are not going to know what the date of commencement is unless we get some confirmation from Mr. Collier about when he received all of the necessary permits. My fear is that one or more of you all, or more significant maybe, or just as significant, someone from the public will say, I've counted the days, we're now at 365 days from this day, December the 20th, and it hadn't been completed over there. We ought to be, or you ought to be, getting $1,000 a day for the taxpayer. Well, that should not be the first time that you figure out when they received all of the permits, right? I mean, you should calculate that day immediately when it happens. I don't know when that's going to be, but I don't want you all to be in the dark or have a question about when the date of commencement is, because it, Mr. Collier can tell us, and he probably has seen it less often than, or maybe never, than other contractors, but the times that I've seen contracts go awry, many times, it's over change orders and it's over delays that go beyond the time that was expected to be substantial completion. So to me, this is significant, and you all need to have a firm grasp on when the date of commencement is going to be. I'm okay with the language as it exists. I'm just telling you, it seems to me you need to be keenly aware of when all necessary permits are going to be obtained, because that stands to be the last date, unless the architect drags their feet about notice to proceed. So that's the first comment I
I
made.
believe that was, if, I don't know if it was just implied or if it was actually written somewhere, it was 30 days after the contract signed, you have mobilization, and then then the time starts, I believe, right?
What permits are we talking about?
I don't know, but I'll read you the
Well, that's
paragraph from
that's
the
a general,
contract. if you
general
want.
contract that, you know, a lot of cities have permits that you have
Yeah,
to
but I
have.
don't,
We don't have any.
we don't have.
Well, it's language from a base contract, is what it's.
Okay.
Well, true, but if you
Yeah.
all agreed with Mr. Collier today, and I said to him that you all on a routine basis approve a contract based upon the condition that it contains the terms that we orally agree to in court. So there's no intention to move past today without the court's approval. You can make the day whatever you want to, but it's on page 2 and it's paragraph 3.1. It says, date of commencement of the work shall be established as follows. And it says you can insert a date or the means to determine that. Well, then what we've inserted, and I say we, I think Michael, commencement date shall be 30 days after the later of the following, A, B, or C. Either receipt of this fully signed agreement, receipt of the notice to proceed from the architect, or receipt of all necessary permits. So it's 30 days after the later of those three things. And my guess is that the permit is typically the issue, but as you just discussed, typically we don't have a permit in Grimes County that's going to be necessary. I say all of that to say you need to know when that date's going to be, because it affects that 365 date that's running. So
be-
you need to be clear on that, and if you all wanted to agree, hey, let's just pick a date today that's 30 days from today, 60 days from today, whatever it is, you would know what that hard date is. If you're waiting for somebody to do something else, if you don't actively go behind Mr. Collier and say, hey, when did you obtain the last permit? Well, then you won't know when that date is. So I just raised that issue as number one. I don't know if we want to address these one at a time, or if you want to hear me ramble on about all my stuff and then shut up.
I think I'd like to address them one at a time, so
Okay.
we put it to bed before we go to the next issue.
Okay.
I believe that one would be 30 days from today, would be the start of the.
So
do you
would
want to
that
strike
be,
B and C?
number.
Sir?
Do you want to strike B and C is
Yeah.
what you want to do? Mr. Collier, what do you think about that?
What we'll do when we start off is we'll make a job schedule, and it'll show all, we'll have a pre-construction meeting before we get out there and get started. And in the job schedule, we'll show the starting date, which is whenever the day the contract is signed. And then there's the 30-day window, and then we'll have the 365-day window for construction. And then we'll have we'll have a walkthrough and a substantial completion. And then there's also in the bid document shows for a 30-day window to complete that. And then as we go through the construction process each month, if there's a rain day, or if there's the act of God he mentioned during delay days, we'll put those down and we'll talk about them and agree on them monthly, and then we'll add those onto the schedule. Usually a tag on the bottom that shows, if we can't make this time up, then the new date would be this. So that's tracked throughout the job, and then each month you're updated on the date if it were to change at all.
I've got a question here. Is this, what we're doing today is 101. This takes care of the 90-day acceptance that we were having a discussion about last time, whether it
Yes.
was 60. Okay,
Yeah.
so
We're good.
we're gonna lock it in today. We're not gonna have any problems with that.
Yes, sir.
Okay.
This is just, discussion when the 365 days start. So
Right.
That's, will be, what we're figuring, it's.
Let me ask
one of
Ms.
those
Nichols,
three, which would be 30 days.
Do you have a contract in hand that we have the ability to sign today?
We've got a bunch. Mr. Collier has one he's already told me about. But I think a bunch of people have this contract in hand.
And I guess that's my point. I'm assuming that if we go ahead and there is a place for your signature on this 101, this locks us in and we're not in jeopardy of the 90-day requirement.
Correct.
Correct.
But I've got an issue, or a question. This is just the initial contract is what I'm gonna call it, I guess, the 101. But the 201 is actually what's descriptive of the work to be done. Will that come at another time? Do we have to sign that today as well?
No, well, it's supposed to be an attachment. You'll see all of those attachments are listed on, it's in Article 9.
Yep.
This agreement is comprised of the following documents. So all of those are supposed to be part and parcel of this contract.
Okay. And those are, okay, I'll look
And
at those.
I saw those originally in form documents, and I don't know there's been any tinkering with those at all. So I think as part of the bid packet, those have remained the same.
I think you're correct. I have not been advised that there's been any changes to those particular documents. Do you have any?
It's on the front page, it says AI document 201 is incorporated here by reference.
Okay.
So it has not been changed, other than what's in the specifications.
Does that answer your question?
Yes.
Okay. Well, and so I guess what I'm saying, and I heard what the fellow with Mr. Collier said, but if you want to make it as simple as that.
You're Mr.
30
Collier also, aren't you? Yes. So it's Mr. Collier and Mr.
Mr.
Collier.
Collier? All right.
Mr. and Mr. Collier.
All right. 30 days from the receipt of the fully executed agreement is when the date of commencement is what I heard, right?
Mhm.
So you could strike B and C
Mhm.
and be good.
Mhm.
That's what I would recommend you do,
Okay,
if everybody's okay with that, including the Collier.
Yeah.
All right.
okay.
All right, so we're gonna strike B and C, and I'll move on to my next thing. I recall the guy from Vanner the other day telling us the numbers. I just want to be sure, as you can imagine, material terms ought to be something that you ought to be keenly aware of, and the cost of this contract is for most material terms. So on page 3, paragraph 4.1, 10,330,000. Just want to be sure that's the right number.
No.
Not.
Well, we agreed in our meeting on Wednesday that we're adding the 125,000
Well, that's
for.
paragraph, another.
Yeah, that's
Okay, all
the next
right.
paragraph.
The 10,330 is correct.
All right, all right. I just want to be sure that was it. All right, and then let's go to that liquidated damage provision we've been talking about.
I think Mr. Collier had it.
So
Well,
that
it's-
number-
it's-
The one that Michael sent us is 10,445.
Well, it's the base plus the alternate, so we'll approve both of them, yes,
Yeah, as long as the language says it's including.
yeah.
Well, let's see. The
It'll be
way that it
10.
reads now, I'll just tell you the way that it reads now, we may need to tinker with that. The way that it reads, 4.1, the owner shall pay the contractor the contract sum, and those terms are capitalized, which means they're defined somewhere, in current funds for the contractor's performance of the contract. Contract sum shall be $10,330,000, subject to additions and deductions as provided in the contract documents. Then 4.2.1 says, alternates, if any, included in the contract sum are 125 for the driveway addition. So it seems to me that 125 ought to be included with, added to that 10,330.
Yes, sir.
Yeah, it will be, yeah.
All right, so that number instead of 10,330 up there should be, what'd you say, Mr. Clark?
10,455.
10,455.
Yes.
See, now you're thanking me for
Well, that's
making
what
them
my
go
version
through this.
says. I don't know which
I don't know why
one.
mine doesn't say that.
Mine, this is the last one
Huh.
I got from,
Mary just got, her last one doesn't say that either.
And who did that? Who did that one? Michael?
This
Michael,
came from Michael, as far as I know. Yeah,
from his secretary.
all right. So let's go to liquidated damages, bottom of paragraph, bottom of that page, page 3, paragraph 4.5. He has in that 3-line provision, and to me, it just left some vagueness that I'd rather let's not deal with. Nobody wants to see us get to this place, but by golly, you're not, not everybody's gonna be happy if we're in this liquidated damage provision. So we need to get it fleshed out now before people have different ideas about what it says. Because you all have heard me say this, if and when you ever take a contract to a judge for review, the judge will apply the four corners doctrine. The judge will look at the four corners of the document. But if there's any vagueness or ambiguity, the judge will say, I will allow parole evidence, which is testimony from those that didn't get entered into the contract, to testify to their intent. Well, of course, if you're in a fight where somebody's got to pay and somebody's supposed to get paid, some guy's going to say, I thought it said this, and the other guy's going to say, no, I thought it said that. And so, to the degree that you can make it as clear as humanly possible, even involving lawyers, and to the degree you can do it, that's what you want to do. Now, I went from 3 lines to 6 or 8 lines, and so I know that's just me being me. But here, I'm going to read it out now. We'll have a record on the video that people want to watch for Christmas. Here's what I put. Owner and contractor agree that if substantial completion, and I capitalize those terms because they have been defined in that 201 document. Owner and contractor agree that if substantial completion, as set forth in paragraph 3.3.1 above, and as defined in paragraph 9.8.1 of AIA document 201-217, general conditions of the contract for construction, is not achieved within the time specified in paragraph 3.3.1, plus any extensions of time permitted pursuant to Article 15 of the AIA document 201-2017. The actual damages sustained by owner because of any such delay will be uncertain and difficult to ascertain, and that the reasonable foreseeable value of the use of the facilities by the owner would be the sum of $1,000 per day. The contractor therefore agrees to pay, and the owner agrees to accept as liquidated damages and not as penalty, the sum of $1,000 per day for each day's delay in achieving substantial completion beyond the time specified in paragraph 3.3.1 above, and any extensions of time permitted pursuant to Article 15 of the AIA document 201-2017. That clear as mud?
Absolutely.
It's clear to me, since it puts a static number in of 1,000. It's not gonna be 795 or 830 or 410. It's gonna be 1,000 a day.
It doesn't change the intent of Michael's paragraph, but what it does is it refers to the definition of substantial completion that already exists. That's not capitalized in the verbiage that already came to you. In fact, the term is substantially complete, not the phrase substantial completion, which is a defined term. So what I then did was incorporate the definition of substantial completion from the 201 document, as well as Article 15, which is the process whereby, act of God, somebody else's fault, they file a claim with the architect, ask for an extension of time. Michael somebody tried to tinker with that, I think, and put that in that language, and I'm thinking to myself, we don't need to go reinventing the wheel. It's already, the wheel is invented in 201. So all we need to do is reference 201, and that's what I did.
And that substantial completion is that 30-day extension at the end when we go through the punch list, is that correct or not?
Well, we can pull out 9.8, but it says when a building is usable is, I think, something to that effect. Do you have 201 in front of you?
Me, no.
Okay. I have it somewhere. Give me just a second. See if I can find it.
I have the 201-2017, but.
Yeah, that's what I'm
That's it.
saying. You got
But
that one?
I don't have that document. I just got that reference.
Okay. It's 9.8? All right. So substantial, this is 9.8.1 in that document. Substantial completion is the stage of the progress of the work when the work or designated portion thereof is sufficiently complete in accordance with the contract document so that the owner can occupy or utilize the work for its intended use. And there are multiple paragraphs below that, 9.8.2 through 9.8.5, that further describe what substantial completion looks like. And that's my point. It's already defined over there to the nth degree. There's no sense in us tinkering with it in this document.
I'm in agreement, committee. Commissioner?
Good.
Probably construction? Okay.
And then the last note, and Mr. Collier said he brought his pen, he's ready to check the box on litigation. And I will tell you that I think that was always the intent. I'm not sure why that box didn't get checked, but there's a description or the use of the term mediation in multiple different places. My preference is, my hope is that if there is ever an agreement that we can't work out just by folks talking, that it will go to mediation and get settled. My fear is if it doesn't get settled at mediation, we would end up in arbitration. Arbitration is this weird animal that there's a specialized group of lawyers and arbitrators that handle that.
Yep.
And it's really out of your hands, and they make a decision. The decision is made at arbitration as though it were a trial. And because I lack some familiarity with it, and because it's foreign to most people that I talk to, all the mediators that I deal with, they don't even do arbitration. So this would be a process that would be absolutely foreign to us. Rather than doing that, I'd say let's litigate. Obviously, we all hope that it never comes to that.
And again, that's just checking the box, and Mr. Collier's okay with checking the box on that. Great.
He said he'd be happy to check the box for us.
Mr. Folds, do you have any other things that you would like us to be aware of or pay attention to?
Judge, you know that there are, I want to say, and this may be an exaggeration, but I don't believe it is, hundreds of pages involved in these various documents that are attached.
Yes.
This is a product of lawyers. This is a product of folks running into problems before, and then lawyers thinking they could solve the problem by adding 5 pages of text.
Right.
There is no way that any one of you or that I could memorize all that's contained in here. My hope is that based on what all good things you have heard about Collier Construction, that there won't be any issues at all. You know that contracts are written so that everybody has a base level of expectation, and that those expectations don't go unmet. But again, it's impossible for anybody to memorize all the terms that are in here. One would hope that if an issue arises, that without pulling out the contract, going down to page 7, paragraph 4.2.6. Whatever, this is how we're going to fix it, we'd shake hands and say, hey, this is the right thing to do, and this is how it's going to be done.
Okay.
But sometimes there is need for having stuff in writing for folks to go back and refer to. So I have set out the things that have appeared most significant to me. We may very well find that there are things in here that don't work for the parties in this situation. You can modify the contract as we go down the road. Hopefully that won't be needed. But I've pointed out the things that were of concern to me.
Thank you. Building committee members, y'all have any issues or concerns?
I do. I would like for you to clarify a little bit for me, John, here on the 6.1, the initial decision maker.
Is that the 201 or the 101?
101.
Okay. 6 point what?
1.
All right.
It defines the initial decision maker as the architect.
Yeah.
Is that something that, are we allowed to dispute the decision made by the initial decision maker?
There is a mechanism in Article 15, which is in 201. Article 15 is how you solve problems if you can't
Okay.
do it by handshake. The contractor files a claim. It goes to the decision maker. One of the types of claims that can be filed is, I need extension of time. There are other kinds of claims that are defined in Article 15. The decision maker says, you're claiming an act of God, it was just raining a little bit, you could have kept working. And so the decision maker could say, no, I'm deciding against you. Or the decision maker could decide in his favor. And either party who feels aggrieved by that decision is entitled to ask for mediation. That's where that mediation first comes in. Then if you don't resolve mediation, you could litigate that issue. Let's hope we don't get to that point, obviously.
Okay.
And you could appoint somebody else as a decision maker. This is the
Well, I
standard
guess
form.
that's leading to my next question. Is that something that the court wants to consider at this time, or, I mean, can you do it? I guess we could do it later.
What's that, change the decision maker? Part of the contract, you couldn't unilaterally change it later. This is being agreed to by Collier. So both parties are saying, fine by me, we'll name the architect as the guy to make the call. If you all could agree together, the two parties could agree to change it, you could change it. If there was some reason to put somebody else in there, but you couldn't do it unilaterally.
Is the court comfortable with that?
Well, the architect has the, say so about, helps understand as far as construction, what the time is. He's a good representative of, rainy days, keeps up with that type of stuff.
I guess the question is, who are you planning on putting in there if you don't put him in there, them in there? I don't know who you put in there.
Well, it's not the decision maker on a change order, a decision, it would still come to us for that, and then
Well,
but
I
they
mean,
would
that-
help determine
Okay.
the length of time
Okay.
that would be added for a change order,
Okay.
or
All right.
something like that, yeah.
And then on 8.2, it's left blank as far as who the actual owner's representative is.
Yes, sir.
Do we want to define that?
Fine by me. If you wanna pick the committee, you wanna pick one of you, you wanna put, I mean, you'd put Grimes County Care of, and then whoever that person is. But the address, I think, right now is the judge's address, isn't it?
I don't know.
I think
Is that
that's
your address?
that's the courthouse address.
Y'all wanted to find that, or just,
Well,
Was
it'd be
that the P.O.
benefit,
box?
and it also has a possibility for email. It'd be a benefit to Mr. Collier. The issue would be if he wanted to get, if his company wanted to get in touch with the representative, is he chasing his tail? Hey, do I talk to this guy? Do I talk to that guy? Hey, I called and I wrote and I did all this stuff. Well, if it's not in here, then he may be left with a question mark of who he's supposed to be talking to. So
I could
certainly not
volunteer
hurt.
for that if that's, as far as a contact from the court, or you said, is it owner's contact?
it's the owner's representative?
It says name, address, email, and other information, and we only have 100 Main Street, Anderson, Texas.
Are we
And
going,
that's my office, or my address.
are we going to discuss at any point a project manager?
I believe we are. I don't believe we are today.
We can't do it today because you don't have it.
It's not on the agenda.
Right, well, so you want to put project manager in there? I mean, as the person to contact, and you're going to designate who that is? Right now, it's 100 Main Street. It's the only address that Mr. Collier has to contact the representative. It's in the contract.
How important it is to Collier Construction to have that absolutely defined at this moment?
I was gonna suggest you could put to be determined or.
Yeah, that's what I was thinking.
court.
All right, well, put 8.2 project manager to TBD. How about that?
Yeah.
8.2,
It's 8.2, yes, sir?
okay. Does that satisfy your question, Mr. Cox?
Yes, sir.
Commissioner? Do you have any other concerns?
No, nothing other than the date on the initial page at the top probably needs to be changed.
On the 18th of November.
Commissioner Dobianski, do you have anything further?
I don't have any
I'm
questions.
gonna turn it back over to the building committee at this point.
No, I'm good.
Then you wanna make a motion?
Yeah, I move we approve the contract for the construction of the Justice Center with Collier Construction in the amount of $10,455,000 for the base bid and alternate number 1, with the revision of paragraph 3.1 to strike B and C. And the added language for the liquidated damages as presented by the county attorney. And with paragraph 6.2, the box check for litigation on a court of competent jurisdiction. And 8.2, project manager will be determined, and with the revision of today's date on the contract.
Second.
There's a motion before the court on agenda item number 2 by Commissioner Mallett, seconded by Commissioner Cox. I have a question for County Clerk and Cherie. Do y'all have all of those changes, additions, language that was just shared?
Sure.
Okay. Mr. Collier, what we just expressed, is that where you're at also?
Yes.
Is there any further discussion? Hearing none, all in favor say aye. Aye. Opposed? Motion carries. Will take us to agenda item number 3. Is there a motion to adjourn?
I move we adjourn.
Second.
I think we'll get it done.
Agenda item number 3, motion by Commissioner Dobianski, seconded by Commissioner Mallett. Is there further discussion? Hearing none, all in favor say aye.
Aye.
Opposed? Motion carries.